This is an audio Codal for the revised rules of evidence. Rule 128, General Provisions. Section 1, Evidence Defined. Evidence is the means, sanctioned by these rules, of ascertaining in a judicial proceeding the truth respecting a matter of fact. Section 2, Scope. The rules of evidence shall be the same in all courts and in all trials and hearings, except as otherwise provided by law or these rules. Section 3, Admissibility of evidence. Evidence is admissible when it is relevant to the issue and not excluded by the Constitution, the law, or these rules. Section 4, Relevancy, Collateral matters. Evidence must have a relation to the fact and issue as to induce belief in its existence or non-existence. Evidence on collateral matters shall not be allowed except when it tends in a reasonable degree to establish the probability or improbability of the fact and issue. So that's the end of Rule 128, General Provisions. Next, Rule 129, What need not be proved. Section 1, Judicial notice when mandatory. A court shall take judicial notice without the introduction of evidence of the existence and territorial extent of states, their political history, forms of government, and symbols of nationality, the law of nations, the admiralty and maritime courts of the world and their seals, the political constitution and history of the Philippines, official acts of the legislative, executive, and judicial departments of the national government of the Philippines, and laws of nature, the measure of time, and the geographical divisions. Section 2, Judicial notice when discretionary. A court may take judicial notice of matters which are of public knowledge or are capable of unquestionable demonstration or ought to be known to judges because of their judicial functions. Section 3, Judicial notice when hearing necessary. During the pretrial and the trial, the court, motu proprio or upon motion, shall hear the parties on the propriety of taking judicial notice of any matter. Before judgment or on appeal, the court, motu proprio or upon motion, may take judicial notice of any matter and shall hear the parties thereon if such matter is decisive of a material issue in the case. Section 4, Judicial admissions. An admission, oral or written, made by the party in the course of the proceedings in the same case does not require proof. The admission may be contradicted only by showing that it was made through a palpable mistake or that the imputed admission was not in fact made. So that's the end of Rule 129, What need not be proved. Rule 130, The rules of admissibility. A. Object or real evidence. Section 1, Object as evidence. Objects as evidence are those addressed to the senses of the court. When an object is relevant to the fact and issue, it may be exhibited to, examined, or viewed by the court. B. Documentary evidence. Section 2, Documentary evidence. Documents as evidence consists of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent, or other modes of written expression offered as proof of their contents. Photographs include still pictures, drawings, stored images, X-ray films, motion pictures, or videos. 1. The original document rule. Section 3, original document must be produced, and the exceptions. When the subject of inquiry is the contents of a document, writing, recording, photograph, or other record, no evidence is admissible other than the original document itself, except in the following cases. A. When the original is lost or destroyed or cannot be produced in court without bad faith on the part of the offerer. B. When the original is in the custody or under the control of a party against whom the evidence is offered, and the latter fails to produce it after reasonable notice, or the original cannot be obtained by local judicial processes or procedures. C. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established from them is only the general result of the whole. D. When the original is a public record in the custody of a public officer or is recorded in a public office. And E. When the original is not closely related to the controlling issue. Section 4, Original Document. A. The original of a document is the document itself or any counterpart intended to have the same effect by a person executing or issuing it. An original of a photograph includes the negative or any print therefrom. If data is stored in a computer or a similar device, any printout or other output readable by sight or other means shown to reflect the data accurately is an original. B. A duplicate is a counterpart produced by the same impression as the original or from the same matrix or by means of photography, including enlargements and miniatures, or by mechanical or electronic re-recording, or by chemical reproduction, or other equivalent techniques which accurately reproduce the original. C. A duplicate is admissible to the same extent as an original unless 1. A genuine question is raised as to the authenticity of the original, or 2. In the circumstances, it is unjust or inequitable to admit the duplicate in lieu of the original. 2. Secondary evidence. Section 5. When original document is unavailable. When the original document has been lost or destroyed or cannot be produced in court, the offerer, upon proof of its execution or existence and the cause of its unavailability, without bad faith on his or her part, may prove its contents by a copy or by recital of its contents in some authentic document, or by the testimony of witnesses in the order stated. Section 6. When original document is in adverse party's custody or control. If the document is in the custody or under the control of the adverse party, he or she must have reasonable notice to produce it. If, after such notice and after satisfactory proof of its existence, he or she fails to produce the document, secondary evidence may be presented as in the case of its loss. Section 7. Summaries. When the contents of documents, records, photographs, or numerous accounts are voluminous and cannot be examined in court without great loss of time, and the facts sought to be established is only the general result of the whole, the contents of such evidence may be presented in the form of a chart, summary, or calculation. The originals may be available for examination or copying, or both, by the adverse party at a reasonable time and place. The court may order that they may be produced in court. Section 8. Evidence admissible when the original document is a public record. When the original of a document is in the custody of a public officer or is recorded in a public office, its contents may be proved by a certified copy issued by the public officer in custody thereof. Section 9. Party who calls for a document not bound to offer it. A party who calls for the production of a document and inspects the same is not obliged to offer it as evidence. Number 3. Parole evidence rule. Section 10. Evidence of written agreements. When the terms of an agreement have been reduced to writing, it is considered as containing all the terms agreed upon, and there can be, as between the parties and their successors in interest, no evidence of such terms other than the contents of the written agreement. However, a party may present evidence to modify, explain, or add to the terms of the written agreement if he or she puts an issue in a verified pleading, A. An intrinsic ambiguity, mistake, or imperfection in the written agreement. B. The failure of the written agreement to express the true intent and agreement of the parties thereto. C. The validity of the written agreement. Or D. The existence of other terms agreed to by the parties or their successors in interest after the execution of the written agreement. The term agreement here also includes wills. 4. Interpretation of documents. Section 11. Interpretation of a writing according to its legal meaning. The language of a writing is to be interpreted according to the legal meaning it bears in the place of its execution, unless the parties intend otherwise. Section 12. Instrument construed so as to give effect to all provisions. In the construction of an instrument, where there are several provisions or particulars, such a construction is, if possible, to be adopted as will give effect to all. Section 13. Interpretation according to intention, general and particular provisions. In the construction of an instrument, the intention of the parties is to be pursued, and when a general and a particular provision are inconsistent, the latter is paramount to the former. So a particular intent will control a general one that is inconsistent with it. Section 14. Interpretation according to circumstances. For the proper construction of an instrument, the circumstances under which it was made, including the situation of the subject thereof and of the parties to it, may be shown, so that the judge may be placed in the position of those whose language he or she is to interpret. Section 15. Peculiar signification of terms. The terms of a writing are presumed to have been used in their primary and general acceptation, but evidence is admissible to show that they have a local, technical, or otherwise peculiar signification, and were so used and understood in that particular instance, in which case the agreement must be construed accordingly. Section 16. Written words control printed. When an instrument consists partly of written words and partly of a printed form, and the two are inconsistent, the former controls the latter. Section 17. Experts and interpreters to be used in explaining certain writings. When the characters in which an instrument is written are difficult to be deciphered, or the language is not understood by the court, evidence of persons skilled in deciphering the characters or who understand the language is admissible to declare the characters or the meaning of the language. Section 18. Of two constructions, which preferred. When the terms of an agreement have been intended in a different sense by the different parties to it, that sense is to prevail against either party in which he or she supposed the other understood it, and when different constructions of a provision are otherwise equally proper, that is to be taken which is the most favorable to the party in whose favor the provision was made. Section 19. Construction in favor of natural right. When an instrument is equally susceptible to two interpretations, one in favor of natural right and the other against it, the former is to be adopted. Section 20. Interpretation according to usage. An instrument may be construed according to usage in order to determine its true character. C. Testimonial evidence. 1. Qualification of witnesses. Section 21. Witnesses, their qualification. All persons who can perceive and perceiving can make known their perception to others may be witnesses. Religious or political belief, interest in the outcome of the case, or conviction of a crime, unless otherwise provided by law, shall not be a ground for disqualification. Section 21, which refers to the disqualification by reason of mental incapacity or immaturity, has since been deleted. Section 22, testimony confined to personal knowledge. A witness can testify only to those facts which he or she knows of his or her personal knowledge, that is, which are derived from his or her own perception. Section 23, disqualification by reason of marriage. During their marriage, the husband or the wife cannot testify against the other without the consent of the affected spouse, except in a civil case by one against the other, or in a criminal case for a crime committed by one against the other, or the latter's direct descendants or ascendants. Section 24, disqualification by reason of privileged communication. The following persons cannot testify as to matters learned in confidence in the following cases. A. The husband or the wife, during or after the marriage, cannot be examined without the consent of the other as to any communication received in confidence by one from the other during the marriage, except in a civil case by one against the other, or in a criminal case for a crime committed by one against the other, or the latter's direct descendants or ascendants. B. An attorney or person reasonably believed by the client to be licensed to engage in the practice of law cannot, without the consent of the client, be examined as to any communication made by the client to him or her, or his or her advice given thereon in the course of, or with a view to, professional employment. Nor can an attorney's secretary, stenographer, or clerk, or other persons assisting the attorney be examined without the consent of the client and his or her employer concerning any fact, the knowledge of which has been acquired in such capacity, except in the following cases. Subpoint I. Furtherance of crime or fraud. If the services or advice of the lawyer were sought or obtained to enable or aid anyone to commit or plan to commit what the client knew or reasonably should have known to be a crime or fraud. Subpoint II. Claimants through the same deceased client. As to any communication relevant to an issue between parties who claim through the same deceased client, regardless of whether the claims are by testate or intestate or by inter vivos transaction. Subpoint III. Breach of duty by lawyer or client. As to a communication relevant to an issue of breach of duty by the lawyer to his or her client, or by the client to his or her lawyer. Some point IV, document attested by the lawyer. As to any communication relevant to an issue concerning an attested document to which the lawyer is an attesting witness, or subpoint V, joint clients. As to communication relevant to a matter of common interest between two or more clients, if the communication was made by any of them to a lawyer retained or consulted in common when offered in an action between any of the clients, unless they have expressly agreed otherwise. Section 24C. A physician, psychotherapist, or person reasonably believed by the patient to be authorized to practice medicine or psychotherapy cannot, in a civil case, without the consent of the patient, be examined as to any confidential communication made for the purpose of diagnosis or treatment of the patient's physical, mental, or emotional condition, including alcohol or drug addiction, between the patient and his or her physician or psychotherapist. This privilege also applies to persons, including members of the patient's family, who have participated in the diagnosis or treatment of the patient under the direction of the physician or psychotherapist. A psychotherapist is A person licensed to practice medicine engaged in the diagnosis or treatment of a mental or emotional condition, or B, a person licensed as a psychologist by the government while similarly engaged. Section 24D, a minister, priest, or person reasonably believed to be so cannot, without the consent of the affected person, be examined as to any communication or confession made to or any advice given by him or her in his or her professional character in the course of discipline enjoined by the church to which the minister or priest belongs. E, a public officer cannot be examined during or after his or her tenure as to communications made to him or her in official confidence when the court finds that the public interest would suffer by the disclosure. The final paragraph of Section 24 says that communication shall remain privileged even in the hands of third persons who may have obtained the information, provided that the original parties to the communication took reasonable precaution to protect its confidentiality. 2. Testimonial privilege. Section 25. Parental and filial privilege. No person shall be compelled to testify against his or her parents, other direct ascendants, children, or other direct descendants, except when such testimony is indispensable in a crime against that person or by one parent against the other. Section 26. Privilege relating to trade secrets. A person cannot be compelled to testify about any trade secret unless the non-disclosure will conceal fraud or otherwise work injustice. When disclosure is directed, the court shall take such protective measures as the interest of the owner of the trade secret and of the parties and the furtherance of justice may require. Number 3. Admissions and confessions. Section 27. Admission of a party. The act, declaration, or admission of a party as to a relevant fact may be given in evidence against him or her. Section 28. Offer of compromise not admissible. In civil cases, an offer of compromise is not an admission of any liability, and it is not admissible in evidence against the offerer. Neither is evidence of conduct nor statements made in compromise negotiations admissible, except evidence otherwise discoverable or offered for another purpose, such as for proving bias or prejudice of a witness, negativing a contention of undue delay, or proving an effort to obstruct a criminal investigation or prosecution. In criminal cases, except those involving quasi-offenses, criminal negligence, or those allowed by law to be compromised, an offer of compromise by the accused may be received in evidence as an implied admission of guilt. A plea of guilty, later withdrawn, or an unaccepted offer of a plea of guilty to a lesser offense is not admissible in evidence against the accused who made the plea or offer. Neither is any statement made in the course of a plea bargaining with the prosecution which does not result in a plea of guilty or which results in a plea of guilty later withdrawn admissible. An offer to pay or the payment of medical, hospital, or other expenses occasioned by an injury is not admissible in evidence as proof of civil or criminal liability for the injury. Section 29. Admissions by third party. The rights of a party cannot be prejudiced by an act, declaration, or admission of another, except as herein provided. Section 30. Admission by co-partner or agent. The act or declaration of a partner or agent authorized by the party to make a statement concerning the subject or within the scope of his or her authority and, during the existence of the partnership or agency, may be given in evidence against such party after the partnership or agency is shown by evidence other than such act or declaration. The same rule applies to the act or declaration of a joint owner, joint debtor, or other person jointly interested with the party. Section 31. Admission by conspirator. The act or declaration of a conspirator in furtherance of the conspiracy and during its existence may be given in evidence against the co-conspirator after the conspiracy is shown by evidence other than such act or declaration. Section 32. Admission by privies. When one derives title to property from another, the latter's act, declaration, or omission in relation to the property is evidence against the former if done while the latter was holding title. Section 33. Admission by silence. An act or declaration made in the presence and within the hearing or observation of a party who does or says nothing when the act or declaration is such as naturally to call for action or comment if true, and when proper and possible for him or her to do so, may be given in evidence against him or her. Section 34. Confession. The declaration of an accused acknowledging his or her guilt of the offense charged or of any offense necessarily included therein may be given in evidence against him or her. Number 4. Previous conduct as evidence. Section 35. Similar acts as evidence. Evidence that one did or did not do a certain thing at one time is not admissible to prove that he or she did or did not do the same or a similar thing at another time, but it may be received to prove a specific intent or knowledge, identity, plan, system, scheme, habit, custom or usage, and the like. Section 36. Unaccepted offer. An offer in writing to pay a particular sum of money or to deliver a written instrument or a specific personal property is, if rejected without valid cause, equivalent to the actual production and tender of the money, instrument, or property. Section 36, for testimony generally confined to personal knowledge, hearsay excluded, has been transposed to Section 22, which is now testimony confined to personal knowledge. Number 5. Hearsay. Section 37. Hearsay. Hearsay is a statement other than one made by the declarant while testifying at a trial or hearing, offered to prove the truth of the facts asserted therein. A statement is 1. An oral or written assertion, or 2. A non-verbal conduct of a person, if it is intended by him or her as an assertion. Hearsay evidence is inadmissible except as otherwise provided in these rules. A statement is not hearsay if the declarant testifies at the trial or hearing and is subject to cross-examination concerning the statement, and the statement is A. Inconsistent with the declarant's testimony and was given under oath subject to the penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. B. Consistent with the declarant's testimony and is offered to rebut an express or implied charge against the declarant of a recent fabrication or improper influence or motive. Or C. One of identification of a person made after perceiving him or her. 6. Exceptions to the hearsay rule. Section 38. Dying declaration. The declaration of a dying person made under the consciousness of an impending death may be received in any case wherein his or her death is the subject of inquiry as evidence of the cause and surrounding circumstances of such death. Section 39. Statement of decedent or person of unsound mind. In an action against an executor or an administrator or other representative of a deceased person, or against a person of unsound mind, upon a claim or demand against the estate of such deceased person or against such person of unsound mind, where a party or a signer of a party or a person in whose behalf a case is prosecuted testifies on a matter of fact occurring before the death of the deceased person or before the person became of unsound mind, any statement of the deceased or the person of unsound mind may be received in evidence if the statement was made upon the personal knowledge of the deceased or the person of unsound mind at a time when the matter had been recently perceived by him or her and while his or her recollection was clear. Such statement, however, is inadmissible if made under circumstances indicating its lack of trustworthiness. Section 40, Declaration against interest. The declaration made by a person deceased or unable to testify against the interest of the declarant, if the fact asserted in the declaration was at the time it was made so far contrary to the declarant's own interest that a reasonable person in his or her position would not have made the declaration unless he or she believed it to be true, may be received in evidence against him or herself or his or her successors in interest and against third persons. A statement tending to expose the declarant to criminal liability and offered to exculpate the accused is not admissible unless corroborating circumstances clearly indicate the trustworthiness of the statement. Section 41, Act or Declaration about Pedigree. The act or declaration of a person deceased or unable to testify in respect to the pedigree of another person related to him or her by birth, adoption, or marriage, or, in the absence thereof, with whose family he or she was so intimately associated as to be likely to have accurate information concerning his or her pedigree, may be received in evidence where it occurred before the controversy and the relationship between the two persons is shown by evidence other than such act or declaration. The word pedigree includes relationships, family genealogy, birth, marriage, death, and the dates when and the places where these facts occurred, and the names of the relatives. It embraces also facts of family history intimately connected with pedigree. Section 42. Family reputation or tradition regarding pedigree. The reputation or tradition existing in a family previous to the controversy in respect to the pedigree of any one of its members may be received in evidence if the witness testifying thereon be also a member of the family, either by consanguinity, affinity, or adoption. Entries in family Bibles or other family books or charts, engravings on rings, family portraits, and the like may be received as evidence of pedigree. Section 43, Common reputation. Common reputation existing previous to the controversy as to boundaries of or customs affecting lands in the community and reputation as to the events of general history important to the community or respecting marriage or moral character may be given in evidence. Monuments and inscriptions in public places may be received as evidence of common reputation. Section 44, part of the rest just stay. Statements made by a person while a startling occurrence is taking place, or immediately prior or subsequent thereto, under the stress of excitement caused by the occurrence with respect to the circumstances thereof, may be given in evidence as part of the res gestae. So also statements accompanying an equivocal act material to the issue and giving it a legal significance may be received as part of the res gestae. Section 45, records of regularly conducted business activity. A memorandum, record, report, or data compilation of acts, events, conditions, opinions, or diagnoses made by writing, typing, electronic, optical, or other similar means at or near the time of or from transmission or supply of information by a person with knowledge thereof, and kept in the regular course or conduct of a business activity, and such was the regular practice to make the memorandum, report, record, or data compilation by electronic, optical, or similar means, all of which are shown by the testimony of a custodian or other qualified witness, is exempted from the rule on hearsay evidence. Section 46, entries in official records. Entries in official records made in the performance of his or her duty by a public officer of the Philippines or by a person in the performance of a duty specially enjoined by law are prima facie evidence of the facts therein stated. Section 47, commercial lists and the like. Evidence of statements of matters of interest to persons engaged in an occupation contained in a list, register, periodical, or other published compilation is admissible as tending to prove the truth of any relevant matter so stated if that compilation is published for use by persons engaged in that occupation and is generally used and relied upon by them therein. Section 48, learned treatise. A published treatise, periodical, or pamphlet on a subject of history, law, science, or art is admissible as tending to prove the truth of a matter stated therein if the court takes judicial notice, or a witness expert in the subject testifies that the writer of the statement in the treatise, periodical, or pamphlet is recognized in his or her profession or calling as an expert in the subject. Section 49. Testimony or deposition at a former proceeding. The testimony or deposition of a witness deceased or out of the Philippines, or who cannot, with due diligence, be found therein, or is unavailable or otherwise unable to testify, that was given in a former case or proceeding, judicial or administrative, involving the same parties and subject matter, may be given in evidence against the adverse party who had the opportunity to cross-examine him or her. Section 50. Residual exception. A statement not specifically covered by any of the foregoing exceptions, having equivalent circumstantial guarantees of trustworthiness, is admissible if the court determines that A. The statement is offered as evidence of a material fact, B. The statement is more probative on the point for which it is offered than any other evidence which the proponent can procure through reasonable efforts, and C. The general purposes of these rules and the interests of justice will be best served by admission of the statement into evidence. However, a statement may not be admitted under this exception unless the proponent makes known to the adverse party sufficiently in advance of the hearing or by the pretrial stage in the case of a trial of the main case to provide the adverse party with a fair opportunity to prepare to meet it, the proponent's intention to offer the statement and the particulars of it, including the name and address of the declarant. Number 7, opinion rule. Section 51, general rule. The opinion of a witness is not admissible except as indicated in the following sections. Section 52, opinion of expert witnesses. The opinion of a witness on a matter requiring special knowledge, skill, experience, training, or education, which he or she is shown to possess, may be received in evidence. Section 53, opinion of ordinary witnesses. The opinion of a witness for which proper basis is given may be received in evidence regarding A. The identity of a person about whom he or she has adequate knowledge, B. A handwriting with which he or she has sufficient familiarity, and C. The mental sanity of a person with whom he or she is sufficiently acquainted. The witness may also testify on his or her impressions of the emotion, behavior, condition, or appearance of a person. Lastly, number 8, first Rule 130, character evidence. Section 54. Character evidence is not generally admissible. Exceptions. Evidence of a person's character or a trait of character is not admissible for the purpose of proving action in conformity therewith on a particular occasion, except A. In criminal cases. 1. The character of the offended party may be proved if it tends to establish in any reasonable degree the probability or improbability of the offense charged. 2. The accused may prove his or her good moral character pertinent to the moral trait involved in the offense charged. However, the prosecution may not prove his or her bad moral character unless on rebuttal. B. In civil cases, evidence of moral character of a party in a civil case is admissible only when pertinent to the issue of character involved in the case. C. In criminal and civil cases, evidence of good character of a witness is not admissible unless such character has been impeached. Then, the last 2 paragraphs. In all cases in which evidence of character or a trait of character of a person is admissible, proof may be made by testimony as to reputation or by testimony in the form of an opinion. On cross-examination, inquiry is allowable into relevant specific instances of conduct. In cases in which character or a trait of character of a person is an essential element of a charge, claim, or defense, proof may also be made on specific instances of that person's conduct. And that's the end of Section 34 and the end of Rule 130.